So what is it that, if you were to ask your friend, that lawyers do, and they would say that lawyers argue, and that's what closing argument's about. Closing argument's the part of the case where you actually get to argue to the jury why your client should win. And it might be the most important part of the case. And why is that? It's the most important part of the case because it's the first time that you have an opportunity to tell the jury how all the facts fit together and why, based on all those facts, your client should win. Now, if you start writing your closing argument the night before your closing, you're going to lose. So you need to be thinking about your closing before you start the trial. What is it about the case? What facts in the case help you win? And you develop those. In your opening statement, you'll hear that you talk about what the facts will show, what the jury's going to hear. And then you put on your witnesses and you put on your evidence and you use your exhibits. And all of that builds to this closing argument. So what is a closing? Closing argument is the time where you take all of those facts and you summarize them. But if that's all you do, you're not going to be an effective lawyer for your client. So what you need to do in closing argument is to mold the facts and talk about them and stress the ones that help your client's case. And so in closing argument, you want to start out by telling the jury why your client should win. Then you need to review the evidence of the case and explain to the jury in as directly as you can why that evidence supports your client's case and why it doesn't support the other case. If one of the other side's witnesses was caught in a big lie, you want to tell the jury about that in your closing because that's really your opportunity to do that. You want to comment on the weaknesses in the other side's case. Remember, if you're the plaintiff in a case, you have to prove. You have the burden of proof. If you're the defendant, it's usually not enough to just say, well, their case is terrible. You've got to point out why you have a good case, and you have to point out why your case is better than the other side's case. And then in closing, a lot of the people that talk about this stuff and read about it say you need to think of a memorable thing to say at the end of a closing argument. And I don't know if you all remember from your U.S. history class when John Adams agreed to defend British soldiers, which was very unpopular at the time. The United States was embroiled in conflict. And so this is what John Adams said in the last line of his closing. He said, "Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passion, they cannot alter the state of the facts and the evidence." And if you go back and read your history book, you'll find that those soldiers who John Adams represented were acquitted. In other words, John Adams, with a powerful closing argument, won his case. So just remember, summarize the evidence. Tell the jury why it makes sense that your client should win and why the other side's case is weaker than yours, and try to end with some memorable thing so that when the jury goes back to the jury room, they're thinking about the evidence and they're thinking about the things you said to them, and you've inspired them to look at the evidence and find in favor of your client. So that's closing argument.